Welcome to OGE's training on letters of recommendation. Today we are going to go over considerations when advising employees on the misuse of position and 18 U.S.C. 205 concerns associated with using official letterhead and title on letters of recommendation. Next slide. When advising colleagues on the ethics issues about letters of recommendation, you'll want to be familiar with 5 CFR 2635-702, 18 U.S.C. 205, and 2 OGE legal advisories, OGE 077 and OGE 9818. Next slide. The regulation related to letters of recommendation is in Subpart G of the Standards of Conduct. These are the provisions relating to proper use of official title and authority and of information and resources to which an employee has access because of his or her federal employment. 5 CFR 2635-702 provides that an employee may not use his public office for the private gain of someone with whom he is affiliated in a non-governmental capacity. Next slide. CFR 2635-702B states, except as otherwise provided in this part, an employee shall not use or permit the use of his government title or position or any authority associated with his public office in a manner that could reasonably be construed to imply that his agency or the government sanctions or endorses his personal activities or those of another. He may sign a letter of recommendation using his official title only in response to a request for an employment recommendation or character reference based upon personal knowledge of the ability or character of an individual with whom he has dealt in the course of federal employment or whom he is recommending for federal employment. Official stationery is to be used for official purposes. Where the employee has not dealt with the person in the course of federal employment, no official purpose is served by the letter recommending that individual other than for federal employment. It is customary for colleagues to request letters of recommendation when they apply for jobs, and letters of recommendation often include the job or profession of the person making the recommendation. 702B is an attempt to balance custom and necessity with the prohibition against the use of public office for private gain. 702B does not determine whether a federal employee can write a letter of recommendation. It restricts when the employee can use his or her position, official title, and letterhead when writing a letter of recommendation. When advising employees, there will be instances when official letterhead is not appropriate. You can remind them that the prohibition does not affect their ability to provide a letter of recommendation on personal letterhead. Federal title and letterhead may be used for recommendations for federal employment because the benefit accrues to the government. In this case, the employee is helping the federal government by providing information about candidates for employment. The government benefits when it has more information. If the applicant is not applying for a federal position, then federal letterhead may be used if the federal employee has dealt with the individual recommended in the course of his or her federal employment, and the federal employee has personal knowledge of the ability or character of the individual making the request. Next slide. Using the diagram, can official letterhead and title be used for these letter requests? A former colleague applying to work for the FTC. The application is for a position at a federal agency. Presumably, the federal employee has personal knowledge of his colleague. The ethics office should mention that this is a criteria for the letter. Junior attorney from a law firm applying to a bank. The position is not with a federal agency, and the knowledge of the requester was not gained in the course of federal employment, so official title and letterhead may not be used. A fellow attendee at a work conference requests a recommendation for a position at a university. The position is not with a federal agency. Confirm that the employee attended the work conference as part of his or her federal official duties, and ask the employee about his or her contact with the requester. 702B states that the letter should be based on the personal knowledge of the ability or character of the individual. Was the contact at the conference sufficient to obtain that knowledge? Next slide. 18 U.S.C. 205 is a federal criminal statute that you'll want to bear in mind. Section 205 does not cover self-representation. It is aimed at prohibiting representational activity on behalf of another. Generally, when considering 205 for the purposes of letters of recommendation, you want to evaluate whether the letter writer would be acting as an agent or attorney for another. The representational activity on behalf of another entails at least some degree of control by the principal over the agent who acts on his or her behalf. Next slide. OGE Legal Advisory 077 deals with immigration support letters. It is concerned with 18 U.S.C. 205 because an immigration support letter will be submitted to federal immigration officials. Character reference, which is opining on the character of an individual, is self-representational. You are not acting as an agent. The letter needs to be under the federal employee's control. The letter should be based on the employee's experience, not coerced. If the person seeking immigration support letter provides a template, then the federal employee is under the control or direction of the requester and not stating his or her personal opinion. When evaluating whether an employee may use his or her title and agency letterhead to write an immigration support letter, rely on the employment recommendation letter guidance. If the basis of the letter is through government employment, then you may use the letterhead. It's a quasi-official act. Again, the contact with the person requesting the letter must have been through the federal employment. Next slide. Further criminal statute considerations for letters of recommendation. If the letter writer is acting as an agent or attorney, then there's a violation of 18 U.S.C. 205. If the letter writer is receiving compensation for representational services, then you'll want to consider 18 U.S.C. 203. 203 prohibits accepting compensation for any representational services relating to a particular matter in which the United States is a party or has a direct and substantial interest. Is the letter writer compensated by an outside source for performing their official federal duties? That would violate 18 U.S.C. 209. And briefly, 209 is a prohibition on the supplementation of an employee's federal salary by any source besides the United States government. Next slide. OGE has issued a legal advisory on other support letters with OGE 9818. It involves letters of support for former supervisor in connection with sentencing proceedings against a former employee. Such letters are of the ilk of character references and involve self-representation. They are not subject to the control or direction of the former supervisor. The requested letter did not raise 205 concerns. Federal employees may use title and letterhead. The regulation clearly sets for a general rule to the effect that use of official title and other accoutrements of public office may not be used in connection with unofficial acts, but then explicitly provides an exception for a character reference based on personal knowledge of an individual with whom the employee has dealt in the course of federal employment. Next slide. Next are some exercises related to letters of recommendation. Exercise 1. Yolanda is a scientist at the National Science Foundation. At her previous university job, she supervised James, another scientist. James is applying for a position at the Food and Drug Administration and asked Yolanda if she would be willing to submit his prospective supervisor at FDA a written reference for him. Is Yolanda permitted to write the reference for James on NSF letterhead? May she sign the letter using her official title? Does 205 prohibit Yolanda from writing the reference for James? Next slide. Exercise 2 is an inquiry from an employee. I wanted to run a question by the ethics office. I recently got an email from a high school classmate. He's following up from our 20-year reunion. He was very interested in my work at the IRS. He's asking if I would be willing to provide a letter of recommendation for his application with the Virginia Department of Taxation. Can I give him the letter? How about a character reference? Next slide. Exercise 3 is an inquiry from the Deputy Director of your agency. I recently gave a presentation on our agency's work and mission for a group of local university students. One of the attendees reached out to me to thank me for the presentation. She also requested a letter of recommendation for her application to graduate school this fall. I'd appreciate your thoughts on this situation. Next slide. Exercise 4. Tony received a request for a letter of recommendation for a leadership position at Meta. Would this be permissible? What information should you obtain in order to give advice and make a determination? Next slide. Exercise 5 is an inquiry sent to the ethics office from an employee at your agency. I received the below inquiry from a former colleague. Please advise. I wondered if you could help me out with my visa application. My immigration attorney says a letter from you, as a respected expert in our field, would be very helpful in demonstrating the United States' interest to keep me in the country so that I can finish my research. If you're willing, my attorney can draft the letter for you. I don't want to bother you with too much with this. Next slide. We'll have a live debrief of the exercises. Next slide. Thank you for your attendance and attention. Have a great rest of your day.